Crystal said, we're here in Hawaii and we could not be more delighted. Of course, we'd love to see your beautiful faces here in this space, but that's okay. We're so happy that everybody in Hawaii is really maintaining safe practices, and you know, we're just delighted, as I said, to be here. So we've been here before, and some of what we will share with you today, we have shared with you before, and some of the things are new. So can I just see a show of hands, however you want to do it, as to whether you've attended one of our sessions before, just so I know whether we're repeating anything. Okay, it doesn't look like anyone's attended other than our wonderful staff people. So, okay, so that's great and that's fine. We just met with our student venture fund directors, including Madonna. We're very happy that Madonna can join us. And so some of what we're going to say today sort of reinforces what we shared with the group of directors. But we're here today to talk about IP for you, and that's IP for entrepreneurs, and how IP can be used by you to not only protect your business, but help you grow your business, which is what it's all about. So what's our plan for today? Our plan is we're going to discuss exactly what intellectual property is, not to be confused with IT. I mean, that's something basic. People often interchange those letters, but we're talking about intellectual property here. We're gonna explain to you why you should be thinking about IP as you develop and grow your business, because we will tell you that IP can protect your business, because what can happen, and knowledge of IP is very useful, because IP issues can and will arise in the course of your working with your businesses, and the earlier you can deal with them to prevent some of these issues, the better. We are going to talk about some important early considerations as you're establishing your company, your business, specifically trademark clearance, ownership and inventorship issues. These all sound very fancy, but they're really pretty simple concepts. IP issues in marketing. There's lots and lots of things that come up when you start marketing your products or services. So launching right into it, what are the types of IP? There are, I would say, 4 basic types of IP. There are some additional types of IP that we're not going to discuss today, but the basic types of IP are trademarks and trade dress. And we're really going to take a little bit of a deep dive on that. Jeff's going to kind of go over some of the details on that. But the most obvious trademarks for you as an entrepreneur are your company name, your company's brands, and your company products, the words. It could be symbols and logos, but it could be the words that are your company name or your brands or your product names. What a trademark does, a good trademark does, is it basically provides, as you start selling your products, your reputation develops around these trademarks, and goodwill will develop. And so, for example, you know, when you think about Lexus or Mercedes-Benz, you think of luxury, high quality, high performance. And so you're getting that by simply looking at the trademark Mercedes-Benz or Lexus. So that's what happens, is once your mark gets more famous, it develops a reputation that is associated with that trademark. Likewise, you're going to find out even sometimes colors can be protected. Jeff is going to go over that with you. The second type of IP that you'll commonly encounter in the course of establishing or growing your business is copyrights. So what are copyrights? Copyrights are art, basically, artistic expressions and creativity, creative works. And so that would include, the most obvious, everybody knows that books are covered by copyright. So are movies, television shows, plays, screenplays, and music, obviously. And then you'll have something even a little less obvious if your business has a very detailed structure on how your business is conducted. And kind of one example for that might be one of these direct marketing companies like an Herbalife or an Arbonne. They have very detailed manuals for each of their I'm not sure what they call them, representatives who will have these manuals and will follow them line by line. And the creativity that went into producing those manuals is actually subject to copyright. And then also for some of you out there, we met with one young man today, a student who is majoring in computer science. Well, the software code that he writes is actually subject to copyright. And so copyright is one of the main ways that, or one of the main avenues that you can use to protect your items that are artistic expressions and subject to copyright. The third type of IP that there is something called trade secrets. And it's exactly that. It's secrets that you use in the course of your business. So it's trade secrets. And those could include, and I say could because sometimes they're not if you don't handle them properly, customer lists, manufacturing methods, how you actually make your product. For example, you know, how puffed Cheetos cheese puffs are made. You know, that might possibly be a trade secret, maybe it's not, but you know, something that's sort of unique and sort of nobody knows how it's made, that could be the subject of a trade secret with respect to a manufacturing method. And then of course, a formula for say a type of plastic or a recipe for a dessert or type of food, that is typically subject to trade secret because the person that, or the company that is marketing that food product does not want everybody to know the recipe, right? Because otherwise it'd be very easy for a competitor to swoop in and grabbing that same recipe and making that same product. And basically then all of a sudden you're losing business to this competitor. And the essence of a trade secret that we're going to go into is keeping your secret sauce secret, keeping it confidential, taking steps to making sure that that trade secret is kept secret. And then finally, the fourth type of IP that we have is patents. And I'm not sure about you, but I will confess that before I joined Knobbe Martens, actually before I really launched my legal career, I really didn't know the difference between a trademark and a patent. And sorry, Jeff, because he lives in the trademark world, but you know, the patents, trademarks, same thing, you know, who knows, who cares? But they're very distinct, and patents are very, very critical to a lot of companies. Patents are often what causes a company valuation to skyrocket, because what it does, and we're going to go into this is it gives the holder of the patent the ability to exclude other companies from making, using, or selling what is claimed in that patent. We're going to go into that in more detail, but basically what patents cover or are directed to are inventions, anything, just about anything under the sun that is made by man. Okay, so not sort of naturally occurring things, but anything under the sun innovated by man that could be patentable. And we will at some point in this presentation have one of our patent lawyer colleagues, one of our colleagues who is a partner at Knobbe Martens, who's going to sign in. And so if you have particular questions on patents, perhaps he can chime in and answer some of your questions. Okay, so where do these IP issues arise? You know, they can arise at any time throughout the sort of life of your company. I don't want to say life cycle because the cycle presumes that, it's going to end, but during the life of your company, you're going to have lots of IP issues come up and you probably won't even realize it. The first time IP issues come up typically is when you're setting up your business. And so it's very, very important. We just talked about this afternoon, to choose a name for your company. And you are going to want to set up a company, because if you want to grow your company or your business, you're going to want to get investors. And investors don't just hand money over to a person. Investors want there to be a company, typically a corporation, that is set up. And if you start using a name, you want to be able to continue using that name. But guess what? If your name is McDonald and you want to open a burger restaurant, you're not going to be able to use the name McDonald's Inc. Okay, you're just not, and for obvious reasons. If your last name was Starbucks and you wanted to open, Starbucks coffee, sorry, it's already taken. So one of the things I wanted to mention is, just because you can get a name with the Secretary of State's office in Delaware or in Hawaii, the Department of Corporations, does not mean that you have the right to use that name for the type of business that you have or for the types of products or services that you offer, because there could be someone else that already has rights in that particular name. So what you want to do early on is search for that name that you want to use, and kind of the more fanciful or the more quaint, the better protectable. And Jeff is going to go into that on how to develop a really great company name. Likewise with your brand names and with your product names, you don't want to choose names that off the bat are going to be infringing trademarks that are being used by other companies. Because what can happen down the road, and it's happened to our clients, is you start getting very successful and all of a sudden somebody sees that you're using a mark, and oh my goodness, it turns out they have a trademark registration for that exact same name in that industry or in that product area, and they could come to you and send you a cease and desist letter. And that's not something you want to be dealing with, once you've kind of got your business going, and you don't need that kind of interruption. You want to make money. You don't want to stop and have to deal with legal issues. As much as we think we're enjoyable to work with, you don't want to hire us to help you sort through those kind of legal issues. And then issues arise with innovation. So for those of you who might be interested in devising technology, then that can range from, medical devices, e-commerce, mechanical devices, you name it, pharmaceuticals, even if you're a chemical engineering major or chemistry major. When you innovate, when you create, like I said, anything that man can make under the sun is possibly patentable. That's where IP issues arise, and you want to start thinking about whether you might want to try to file a patent and get patent protection on that technology. It comes up when you're designing your product, because sometimes you may think, okay, wow, I found a fantastic new way of testing your glucose in your system, in your body. But guess what? There's dozens and dozens of companies out there that have already developed glucose testing, glucose monitoring technology, and chances are pretty good that your device may actually infringe the patents held by other companies. So when you're designing your products, you're going to want, and your investors are going to want you to make sure that you're not only protecting what you've developed, but that you're not designing your products in a way that's going to be infringing other companies. And then, so it's, like I said, it's important to consider filing patent applications, or you may decide, you know what, I'll keep my innovation a top secret. I'll keep it as a trade secret. But again, in order to do that, you have to keep it secret, and you have to take certain steps in order to keep those secret. And we'll go over that. The IP issues arise, as I said, when you're creating when you're creating materials, whether it's, you know, if you're an artist or creating something that is artistic, you know, copyright issues arise. When you're using photos, videos, artwork in the course of your business for your logo, even artwork on your website, IP issues arise. And then when they're really going to arise is when you start getting interest by investors, whether it's friends and family or something a little bit more sophisticated, angel investors, seed investors, hopefully someday venture capital investors, and then private equity investors, and then possibly companies, big companies that want to acquire you for multiples of what you've put into the company. That's a real success story, but they are going to want to look at how you've protected your IP. Jeff is working on 2 transactions right now where, you know, that's front and center is IP issues. So realize that that's going to come up. Also, you know, pre-equity investment, you may want to get a loan, whether it's the SBA or a traditional lender, a bank, or a private party. They're all going to be interested in how you are protecting your innovations, your secret sauce. And they're going to ask questions, and you need to be prepared to answer them. Like I said, when you're designing your products, when you're manufacturing your products, you have to think about, you know, product packaging, how your product's designed. IP issues arise with all of those. And then finally, once you do get IP that can be enforced, you may decide you have a competitor out there that has stolen your name, stolen your recipe, stolen your brands, and they're basically marketing a counterfeit product. And you, at that point, you may decide, you know what, we can't possibly have an inferior product out there. We're losing business to them. We need to take steps to enforce our trademark registrations or our patents against this infringer. And so that's where firms like us come in, where you'd hire a lawyer and try to get that person to stop. Okay, I'm going to now hand it over to Jeff.
Welcome, everyone. So we're going to talk a little bit about trademarks here, a little deeper dive into trademarks. And so as Wendy mentioned earlier, trademarks are really the consumer-facing intellectual property in many cases that you're familiar with, brand names, such as some of these here on the screen, the logos and words and symbols there that consumers will recognize. They understand the source. They know exactly what they're getting in connection with that product. The other nice thing about trademarks is that unlike patents and copyrights, they literally can have an unlimited term. And so trademarks can be used and have rights as long as they are used.
Jeff, how long does a copyright last?
So copyright law differs a little bit country by country. In the US, it's the life of the author, 70 years after the life of the author, of the last author in joint copyright cases. So it is a fairly long time. But it does eventually expire, whereas trademarks do have this end. Oh, I'm gonna switch back to Wendy real quick.
So just real quick. So we thought it would be fun to show you examples of Hawaii-based trademarks. So, you know, Mauna Loa, definitely Hawaiian host, and every company that produces and sells macadamia nut chocolates or chocolate covered macadamias, definitely all of those names used by those companies, the company name, the brand name, and the product name, like Maui Caramax. I imagine Caramax is a trademark, not sure if it's registered, but you know, those are all carefully selected names. So just as these companies have selected names, you should as well. Kona Brewing, very popular. I'm not sure if it's popular here, but very popular on the mainland. Town and Country, TNC Surf Designs. Our favorite, Big Island Candies, which Alan Ikawa is an alum of Scheidler. Fantastic candies. If you haven't tried it, Ala Center, delicious candies, or online. But Big Island Candies has developed quite a wonderful trademark. Likewise, Dole Plantation, Dole Pineapple, famous brand. LNL Hawaiian Barbecue, another alum of Scheidler. Honolulu Cookie Company, you see them all over in Waikiki. And of course, our favorite Zippies. It's usually our first stop when we land in Hawaii. And then of course, the best university in the whole world, sorry about the wait, but University of Hawaii is also a trademark. And so is the emblem or the logo right next to it. So like I said, trademarks are both the name, the words, and also the visual, the logo. That's kind of a more commonly used term for a trademark, is a logo.
So the important thing to understand about trademarks is what I have here, this spectrum of strength. And so the strongest trademarks, I think Wendy mentioned this earlier, are marks that are either fanciful words, totally made up, like Haagen-Dazs, or coined terms. And then as you go a little bit, you have arbitrary trademarks. And so Amazon is a word, is an English word, has a meaning with that, but it's arbitrarily applied to online retail in that regard. So that's also very good.
So
very
like there's
strong.
no connection.
There's no connection, just arbitrary. Apple for computers. Apple, obviously a normal English word, describes primarily a fruit, but Apple for computers is an arbitrary mark, and it's become very strong because of that. In the middle of the road here, we have suggestive marks. And so a lot of times that's where a lot of marks will fit in the suggestive category. Microsoft is an example there of a suggestive mark where you understand what it is from the two components of the mark that are made there. And then we get into descriptive marks. Now, once we get here, we're getting a little weaker. And so the trademark lawyers don't like descriptive marks. Marketing people love descriptive marks. So there's always a little bit of a push and pull there with that. But a descriptive mark would be anything that describes. And descriptive marks are also the category of laudatory marks, geographical marks, surnames all fall into this category of descriptive marks. So it's a very broad category, and a lot of marks fall into there. I've got the example here of American Airlines, very descriptive mark, geographical, and then American, the type of the airlines, the type of service that they're offering. You are protectable through descriptive marks. You may have to jump through a few more hoops for registration and a few more hoops for enforcement, but a descriptive mark can be a trademark. And then we have generic terms. And so generic terms can never achieve any trademark protection. And sometimes marks that were trademarks, like escalator, have become generic and that are no longer protectable. So generic terms would be apple for apples, right? Pineapple for pineapples. Whereas Dole, being a surname, is going to be a descriptive mark in connection with that, but can achieve trademark protection. So this spectrum, we're going to repeat a little bit here because we're going to kind of go through this a little more later in connection with other marks. We talked about a trademark, and I want to draw a distinction here between trademark and the other types of intellectual property. When you develop and use a trademark, you do have rights. You have what we call common law rights in the use of that mark. And those common law rights are geographic in scope. So if you started a business here in Hawaii and the mark is used in Hawaii, you've got some common law rights. You start selling online and you have customers in California and Washington or Nevada, you've got some common law rights in those areas. As you get more customers in Texas or Florida or Massachusetts, you'll have additional rights. Or if you get some rights outside of any of those other states, you've got common law. Those take time and they take a number of kind of quantity in connection with customers. What the other option is going through the registration process. And so there's two levels of registration process, which can complicate it a little bit sometimes. Every state has its own state trademark registration system, but there's a federal trademark registration. So usually when we're talking about trademarks, we're talking about trademarks from the federal level so that you have nationwide protection for the mark in every state and every US territory. So the benefits of registration are significant. They give you prima facie evidence of the ownership and the validity of the trademark. So very, very helpful in enforcement situations. They become what's called incontestable after 5 years. And so, as I mentioned, trademark rights can be common law where you can have a mark and have rights. But if you go through the registration process and you play by the rules of registering your mark, once 5 years of the registration have passed, you don't have to worry about any prior users out there that may be using the mark in connection with that. So it's very important to give some security and some finality to the trademark rights that you have. You can also record your trademark registration with customs, and that prevents importation of counterfeits, knockoffs, and other types of unauthorized goods. Gray market is the term typically for unauthorized goods, where a brand owner puts goods on a certain market in a certain country. They may not be of the same size or quantity or quality or some other factors, but they can come back into the US with that trademark, and we call those gray markets. And so it's a lot of times the customs recordation can help you in that situation. The registrations are very valuable in a company or corporate portfolio. They're used a lot of times for security, collateral, connection with loans and other types of information there. So they are a very good asset. And it's again, it's intellectual property. So it's not like you had to, to buy the land or buy the trucks or buy the inventory, but it can still be used as a corporate asset in the portfolio. And the other thing I want to mention here quickly, so I don't forget it, because I always do, is domain names. And so domain names are kind of on the same level of the status as a trademark. In fact, if you have a trademark or a company name, you typically want the domain name, some domain name that matches up with that as well, in connection with marketing and sales in connection with that. So those need to be looked at as well. You're very familiar with what we're going to call traditional trademarks, which are typically designs or logos, as we'll reference that term in connection with it. Words and letters are also traditional trademarks that are there in connection with it. But there's also some very non-traditional trademarks like sounds. The MGM Lion Roar is a registered trademark. The laugh of the Pillsbury Doughboy is a registered trademark of that sound. And then slogans are also very non-traditional trademarks that can register too. I'm sure if you read through those three slogans, you know exactly what company those are referencing and where those come from. We're going to talk a little bit about protecting your business with IP here. And so as we've already mentioned here, of choosing a good name, and by good we mean typically strong. If you can be on the end of the scale, the spectrum scale, that we'll go into a little bit more of, either the fanciful or coined is best, but arbitrary is great. And the same with brands and product names. If you can choose, strong product and brand names, you're in a good position there of protection in connection with those. Applying for trademark registration, it's a relatively easy, relatively simple process. It used to be relatively quick, not so quick right now at the federal level, but still worthwhile in connection with doing. And all the time that you have these trademarks you're doing, as Wendy mentioned, you're developing reputation and goodwill, and those themselves can be assets and add value, to the company itself. I mean, a lot of the value of the Coca-Cola company is the strength and the value and the reputation of the trademark itself. Same with Walt Disney and others of that kind of nature, Apple, obviously, and those. And so then once you've used and established and hopefully registered your trademark, you can stop others from using the similar trademark, stop that unfair competition in connection with that. So all of that gives you this fence around your business in connection with the trademarks that's worthwhile. Here's my graph again. And so always just kind of keep this in mind, choosing a company name. Now, a lot of times company names that you're going to choose, you're going to be in that descriptive category, because you're going to want to use something geographical. You might want to use something that's a surname in connection with some type of business in connection with your surname. You may want to use something laudatory. You may want to have a word like technology or beauty or medicine or pharmaceuticals. Those all descriptive terms may be part of the company name.
What does laudatory mean?
So laudatory will be like things like best or superior or super or thrifty, those types of terms in connection with that of laudatory. Best Buy is a prime example of a laudatory mark, or thrifty car rental, or thrifty gas stations. The thrifty is a laudatory term in connection with that. That's the problem with descriptive marks. You can have thrifty car rental, you can have thrifty ice cream, you can have thrifty gasoline, because those are products are different, and laudatory marks have, you know, weaker protection, meaning not as big or tall or wide a fence, whatever, you know, kind of analogy you want to make with that. But if you can come up with a suggestive or arbitrary name for your company name, like Apple, then you're great. Same with brand names here. On brand names, we really try to steer more towards the stronger area than with company names, because we understand with company names, again, you might want something geographical or laudatory or a surname in connection with that. But on brand names, if you can, be more towards the arbitrary, you know, or the fanciful or coin term. And then product names, we're going to get more to the descriptive kind of category again, always. And so there's a little bit of back and forth within the business of what you do, because a lot of times for the actual descriptive names, there may be some, again, geographical connection, ingredient connection, color connection with it. That's part of that actual product name. And again, those are a little bit, you know, weaker because of the descriptive nature of those. Now we're going to turn from trademarks temporarily to trade secrets and patents. And I think we have our patent colleague on the phone. So if there's any questions that arise in connection with this area, we've got a great expert.
Let me just introduce him very quickly. So Dr. Jason Gersting, he's a double doctor, JD and a PhD. He is a partner at Knobbe in our Orange County office, and he does a lot of work with medical device and companies that are in the pharmaceutical. He's got also a vaccine area, got a lot of expertise with respect to biotech as well as medical devices, and sometimes the two will merge. So delighted that Jason is here. He's also a Hawaii boy. He grew up on the Big Island, where his dad was a professor at UH Hilo. So someday we will have Jason join us as a guest speaker. But for now, he has graciously agreed to spend his Friday night in California connected to us. And so he'll be happy to answer any questions that might be patent related, since neither Jeff or I is a patent lawyer, but we know enough to be dangerous. So, okay, thanks, Jason, for joining us. Yeah, I think okay, so as I mentioned, another way to protect your IP is through trade secrets and patents. And really, one of the first decision points you're going to need to make as if you're innovating and developing technology is whether to keep your innovation a trade secret, or to go ahead and register or try to register apply for a patent, which basically will give you some protection. What are the advantages of trade secrets? Well, the neat thing about trade secrets, patents have a specific term, but trade secrets can last forever, but only so long as you keep that trade secret secret. So you have to keep that trade secret safe and confidential. For example, as you know, the recipe for Coca-Cola is a trade secret, and it's highly guarded. And I think there are only very, very, very few people within the organization that actually know how Coca-Cola is made. And I think they've developed a process where, you know, it's extraordinarily difficult to even figure out what ingredients go into making Coca-Cola. They're very, very careful. And so the recipe for Coke would be a trade secret. Likewise, one of our alums, Peter Heller at Pono Potions, it's a wonderful set of syrups that he developed using their artisanal syrups, using natural flavors and locally sourced ingredients. For example, there's hibiscus, there's a hibiscus potion is what they call it, but a syrup, a lavender syrup, there's coconut syrup and a pineapple flavored syrup that can be used in coffee or tea or in smoothies or cocktails even. So, but again, no one really knows other than Peter and perhaps his partners what that recipe is. So those innovations, food recipes are definitely, trade secrets of those companies, should be trade secrets of the company. You know, the minute you publish your recipe, a chef publishes the recipe online, it's no longer a trade secret. And I understand what they sometimes do is they tweak the recipe a little bit. So it never tastes quite the same, right? But so that's what a trade secret is it's the secret sauce that needs to be kept secret or else it's not a trade secret. Okay. What are the disadvantages? Well, you always have to worry about theft. Is the chef going to run off with the recipe? You know, is a disgruntled employee going to run off with the trade secret? Are they going to copy it? Can they copy it? That's called trade secret misappropriation, fancy term for trade secret theft. Okay. And if the trade secret is stolen and it's publicized, it's put on the internet, all of a sudden your secret sauce is no longer secret. It's very, very difficult to recover, and you may never be able to regain that status as a trade secret. So that's the problem. You really have to keep it secure. And the other problem with trade secrets is it's kind of hard when you have investors. Sometimes they want to see the recipe. Should they see the recipe? Maybe not. But a lot of the investments that are made by big investors, by angel investors on up to strategic investors, they tend to want to invest in companies that have patent protection as opposed to trade secret protection. So it really depends on the business too. So obviously if it's a food business or a restaurant business, maybe they do have trade secrets, and those are great, and they get investments, they get loans all the time. But if it's, you know, a medical device or a pharmaceutical, the investors, the bankers, they're going to want to see patent protection. So what are patents? As I mentioned, they can cover potentially any innovation under the sun made by man. What are the advantages? As I mentioned, very well regarded, very much valued by investors, bankers, and customers. You know, if a technology company doesn't have a robust patent portfolio, meaning they don't have a lot of patents, you know, the investors are gonna wonder, scratch their heads and wonder, you know, do they not have patent protection because they can't get patents on their technology? Or why didn't they get patents if their technology is patentable? So often there's the expectation there. And once you have a patent, what it does, and I mentioned this before, it gives you the ability to stop others from making, using, or selling your claimed invention. And I'm going to jump to the bottom of the screen here. But what it does not do, it does not give you the right to practice your invention. In other words, if you have patent claims directed to certain features of your product, that doesn't necessarily mean that you have the right to make that product and to stop others from making that product, because other parties may have the patent rights with respect to other aspects of your product. Okay, so your patent, if you get a patent and you get patent claims in the patent, the claims basically claim that you have an invention on something. If you get those claimed inventions, the claims, you only can stop others from making, using, or selling that particular claimed invention. So it's a little difficult to wrap your head around that, but basically a patent doesn't give you the unfettered right to yourself be able to make that product, because it depends on whether you have the right to employ all of those features of your product and to be able to sell it. What are the disadvantages of patents? Well, with a patent, the trick is, with a trade secret, you keep it secret. With a patent, you have to disclose the way in which your product works, basically. That's your secret sauce of your invention. So you do have to describe it in a way that someone who is learned in that art can actually make that product. So you can't like only give away half of your secrets. You have to disclose what your invention is about. There's several other requirements of a patent that I'm not going to get into. But for now, realize that if you go down the patent route, you have to disclose to the public in published form for everyone to see how your invention works. Your patent, if it issues, will last for 20 years from your earliest filing date of your patent application. But you need to understand that another disadvantage is if you make public disclosure of your invention. In other words, if you put your invention out there in certain ways, it could ruin your opportunity to obtain not only a US patent, but foreign patent rights as well. Okay, so just remember, you have to be very careful about showing your product to the world. And we'll go through where you can, yeah, okay. So again, does not give you the right to practice an invention. This picture is worth 1,000 words because loose lips sink ships in the patent area. If you disclose your ideas to the public, and not necessarily to the public, we'll go over some of that, but it may preclude you or basically prevent you from being able to protect your patents, or I'm sorry, your innovations. So there is a 1-year grace period in the US within which you can still disclose your patents, but in many foreign jurisdictions, once you disclose a patent, your innovation to the public, you've lost your patent rights in those foreign jurisdictions. So a rule of thumb is to always consult a patent lawyer before you want to try and do something that might be considered a disclosure, a public disclosure. And then, if you can't get patent rights and you've disclosed your secret sauce, your innovation, your competitors are going to be watching out for those things and they may grab them. And it's not considered a trade secret misappropriation if you put your invention out there. Okay. So what are the ways in which you can lose rights? By giving a speech on this new product that you've innovated. A lot of medical doctors are guilty of this. They present at medical conferences. A lot of scientists, they're so excited, to share with the world what they've done. Likewise, the second item publications, they publish an article about what they've discovered, what they've innovated, and that's a loss of rights scenario. If you apply for a grant, a federal grant, that may be considered a public disclosure. If a PhD student produces a thesis or a dissertation on the technology that was developed, that could be considered a disclosure. If you offer the product for sale, if you offer it for sale to the public, that blows your rights with respect to potentially getting at a minimum foreign rights, foreign patents. If you go to a trade show, when I was in-house counsel for a manufacturing company, I can't tell you the number of times that my salespeople would tell me, "Oh, we're going to Vegas and we're going to show our new product at SEMA, the service industry automotive show, and we hadn't filed for any patents yet on what we thought was our patentable technology." And I said, "No, you don't do that, not yet." Or we just got our act together and we got something on file right away before the show. But that's an example of how an issue comes up at the last second. It's not pleasant because you're in a flurry of activity to try to protect your IP before it actually becomes public. And then finally, when you engage with a separate company to do some beta testing of your product, or if you collaborate with another company to further develop the product, that could be a danger zone where you might possibly lose your IP or your rights to file for patent protection. So what can you do? Well, with respect to trade secrets, you might want to insist on getting an NDA from the company that you're going to share your secrets with. An NDA is a non-disclosure agreement. It can be a fairly short form, and it basically is signed by the other company and promises to keep your trade secret secret. And you should always use your own NDA because it'll be more protective of you than their NDA. Their NDA may say, it's only going to last a year, and your NDA says this lasts for 3 years. So, it's always a good thing to insist on using your own NDA when it's your trade secrets that are at stake, and get some help. There are NDAs out there on the internet, but there's nothing like getting a good NDA from your business attorney or your IP attorney. That can really be protective of you. So the best course of action to prevent a loss of patent rights with public disclosure is file a patent application before there is any disclosure. You don't want to gamble. Some people like Vegas, but when it's your technology, you do not want to gamble here, and you want to get a patent application on file. There's something called a provisional application that's kind of like a placeholder, and it's not terribly complicated. It's not terribly costly, and you can basically get your ideas, and you should do it fairly thoughtfully, prepare it thoughtfully, but then you have a year within which to file a regular patent application. It kind of buys you a little bit of time, but your regular patent application has to be basically based on whatever provisional that you filed. So that's something that you can use as a provisional patent application. Other things that are just basically good practices to do is, make sure that if you've innovated something, that you have evidence when you invented it. And a good piece of evidence is a lab book. It's with dates on it. Documentation. There's a lot of laboratories that have very specific ways of documenting their dates of development. You can use these days. There's no actual books anymore. There used to be those, black and white composing books or composition books, but nowadays there's all kinds of software that you as an inventor could use to document when you innovated your particular invention. Jason, is there anything you want to add on that front on protecting? I don't know if you're at liberty to talk. You're muted. I know he had some carpool duties, so he may be driving, but.
So I think we're out of time.
Oh, we are out of time. Okay. All
But
right.
I want to, so we're going to you'll have the slides here, and feel free to touch base with Wendy and I afterwards. But I did want to go through one final thing because we didn't talk about copyright yet. And I think copyright is very important, just to cover really quickly. And copyright is a different animal than the patents and trademarks we talked about, because copyright law presumes the author or artist is the owner. So as you as a company or a startup company go outside your company, go to a graphic designer, a freelancer, a photographer, they will own the work that they create for your company, even though you've paid for it, unless you get a written copyright assignment. So it's very important that when you're doing any logo design, photography, website design, code writing, that you make sure that your business owns the copyrights in connection with that in that rise. We have one question there. I don't know how we want to do questions, Crystal. So there's a question that's what type of IP would student research be considered? Methods of research that they innovated or engineered, a new drone, for example. So with the student research, it's going to depend, which lawyers always say, it depends. We're going to look at see like how it was funded, what the contractual arrangements the student had in connection with this research. In connection with doing the research, was it funded and was there a contract as to who owns it? Because ownership is always a very key underlying issue in anything. Who is the owner? Sometimes the owner is the person who authored it or was the artist. Other times it's who invented it. Other times with trademarks, it's who first used it. Sometimes by contract, it's who paid for it in that regard. So it really will depend upon the underlying creation of it, what kind of contract, what kind of arrangement, what kind of agreements were there.
And one thing I should note, full disclosure, we have the honor of representing the University of Hawaii with respect to their patent applications. And I do know that the university has some very specific policies on what is owned by the university with respect to research or innovations that come out of their labs and their programs. So, that's a good question. Perhaps PACE can help.
Not just by students, but
by faculty, by grad students. It usually comes up at the grad student level, but we at PACE can certainly facilitate getting the specific answer to that question because there are very well established guidelines on what can be owned by the university versus a student or the faculty member.
So another question was, at what point after applying for the patent can you disclose the invention publicly? So as Wendy mentioned, in the US, and this is just the US, you have this 1-year grace period where you can disclose the invention and you've got the 1 year to get your application on file. That is not true in many foreign jurisdictions where they require no disclosure prior to the application being filed. But then once you have filed the patent, and sometimes you'll do a provisional patent application, as Wendy mentioned, then you've got some comfort level in doing your disclosures after that point. Now, the patent application process is not anything quick. So it may be something that's literally going to take, a couple of years or more to do. So you're not going to hold up your business because until your patent issues, but investors and others may hold up that investing until the patent issues to see how it goes, or at least how it's progressing, in the patent office. But once you've got the patent on file, you secured those rights in connection with that, then you've got some security in doing some public disclosure in the US, after that point. You will not have to wait until it registers. That could be actually a long time for certain technology.
Okay, and then Mira Tenson says, do you know about international students and foreigners starting and owning a business in the US? Or can you refer me to attorneys who specialize in it so I can consult with them? The good thing about the United States is that we don't have a lot of restrictions on foreign nationals, like Mexico, for example. You cannot, a U.S. citizen cannot own property within a certain number of miles from the border. They really restrict things that foreigners can do. The United States is a lot less restrictive, except when it comes to matters of sort of national security. So, if you're thinking of starting, let's grab something out of the air, a business on, making some kind of chocolate confection. I am not aware of any law that would prevent you from making and selling chocolates. So long as you don't, call your business Hawaiian Host or, Godiva. But, but then you do have to think about sort of foreign tax issues, because you're making income in the United States. I don't know the answer to your question, but, most students are not capable of or can't afford to hire attorneys. And so I know there's a Hawaii legal aid, or there's a Hawaii referral service to more affordable legal counsel, and those legal counsel might be able to help you. But those kind of questions, I would imagine somebody would have written on the topic, written an article on the topic, because it's not a question that's unique to Hawaii. It's a question that might have been asked several times on the internet with respect to any foreign student that is studying in the United States. Oh, great.
Yeah.
Tracy, thank you, came to our aid. She can connect you with a tax expert, so you can connect with Tracy later and provide your email. Anyone else? If you, okay, go ahead.
Yeah, at the end, we have our phone numbers and email addresses on there. So please, by all means, reach out to us. We'd be happy to answer any questions. We kind of cut through our presentation pretty
Yeah,
quickly.
sorry, we couldn't get it all in, but you know, we'd love to come back. And we do. We love Hawaii, and we want to support the entrepreneurship ecosystem that is just, I'm so in awe of how well it's developed here, thanks to PACE and thanks to Scheidler and all of you bright and hardworking students. So, you know, get out there, develop your businesses, sell your products and services, and you know,